the Secretary regrets the inadvertent error and genuine misunderstanding of the order of this court, and for which we ask that you exercise your discretion
to do what he pleased. Fifthly, he did not come to court. If there's any difficulty, I am appearing together with the following counsel for the second petitioner, Mr. Owino.
Present, my lady.
Mr. Jared Gekombe.
Present, my lady.
Virtually, we have Mr. Oyo and Ms. Wangari Kagai. They have informed me they've joined virtually.
I appear leading Mr. Kuria Thande, Mr. Moses Kikoge, and Ms. Edith Jerome. My lady, we represent the first to the fourth respondents.
My lady, Malizo Nyawa, I've been requested to hold brief for Ms. Omwom, who appears for the first interested party, Kelin, Kenya. The third interested party normally appears virtually, and I think he is on the screen. He is Mr. Mwangi Maingi. Today's appearance is for the purposes of mitigation and sentencing pursuant to your ruling he delivered on the 22nd of June 2026.
Yes, my lady, on the cited contempt, I would wish to place on record that we are before you this court with the entire leadership of the Ministry of Health. My lady, we are in court with the Honorable Minister, Cabinet Secretary, Ministry of Health, the Honorable Duale, present in court. My lady, the Honorable Duale is also accompanied by the leadership of the ministry, being the permanent secretaries, Dr. Frederick Ouma Oluga, present in court, and Miss Mary Mudhoni, present in court as well. My lady, they are also supported by the heads of the technical operations of the ministry, the Director General, Dr. Patrick Amoth, present in court. We also have the Director General, Kenya Public Health Institute. That is Ms. Maureen Kamene, present in court. My lady, we are ready, and with your permission, we would request to have the Honorable Cabinet Secretary, Honorable Duale, take the stand before I address you briefly. Requiring at the penultimate paragraph the attendance of the Cabinet Secretary for Health, we have this morning complied, and as indicated, the Cabinet Secretary is present in court. My lady, in response to the ruling and as part of mitigation, the Honorable Duale has sworn an affidavit dated and signed on the 22nd of June 2026. I just want to confirm if you have a copy of the affidavit on record. Unfortunately, my lady, and I must apologize to my colleagues because of the shortness of the time, we were only able to file this affidavit this morning, but we've availed a copy to them. It's also available in the CTS. My lady, with your permission, I would now want to introduce to you the Cabinet Secretary. Would you want to kindly introduce yourself to the
Duale, current CS for Ministry.
Thank you very much. Would you want to share your identity?
My number is 126001.
No. Just introducing so that you have complete record. Yes. My lady, I would want to avail a copy of this affidavit to the Honorable Cabinet Secretary.
Swear that the evidence I shall make before this court shall be the truth, nothing but the truth. So help me God.
And this before court is sworn by yourself.
Yes, I confirm.
Would you want to confirm the date?
The date is 22nd of June 2026.
Very well. Would you want to adopt that affidavit for purposes of the mitigation before this honorable court?
I wish to adopt the affidavit filed on this date.
Please also confirm to the court that you understand that you're here for purposes of mitigation in relation to the findings in the ruling of the honorable court delivered yesterday, 22nd of
I confirm.
Adopted the affidavit. We ask that it be adopted as part of the court record in its entirety. matter that you are handling, and because of the sensitivity of what it contains, and also because of the seriousness of what contempt proceedings are, we would want to plead with the court, my lady, to allow the Honorable Cabinet Secretary just to speak to the affidavit and to also just contextualize certain aspects of the affidavit, which may not perhaps be very clear just from a plain reading of the affidavit. And my lady, with your permission, if we could ask for about 15 minutes. 10? Yes. 10 minutes? Very well. Would you kindly just speak through the affidavit on what you consider to be the salient issues in the affidavit?
Honorable, in June 2026, you delivered a ruling finding me in contempt in relation to the proposed Ebola quarantine and isolation facility at Laikipia Air Base. And as I said earlier, I wish to adopt this affidavit of mitigation filed on 2nd June 2026. The content application arose from the conservatory order issued by this Honorable Court on the 28th, subsequently affirmed on June 2026, restraining the ministry from establishing the said quarantine and isolation facility pursuant to any agreement with the United States of America or any foreign government or agency pending the determination of this petition. At the onset, I wish to reiterate my utmost respect for the authority and dignity of this Honorable Court. The Ministry of Health and the Government of Kenya remain firmly committed to the constitutional of the rule of law, respect for court orders, and the independence of the judiciary. Further, it's important to note that any decision made by myself as the Minister for Health, I base them on science, technical advice, and strategic interventions. Immediately upon the conservatory order, and in good faith, compliance with therewith, the Government of Kenya and the United States of America suspended the proposed suspension of the collaboration. The military understanding of the conservatory order was that the court had suspended the implementation of the proposed collaboration between the Government of Kenya and the United States government in relation to the Laikipia. Undermine on act in defiance to serve as a vehicle is scientifically unfounded. The facility is located at a military airbase, placing it at significant geographical distance from populated areas with very strict access protocols, including reducing any theoretical risk of community exposure. We have the Kenyan delegation of soldiers in Congo serving under the UN who are required to travel very often to Kenya for their rotation every 12 months. Some might come to travel to see their families during leave, as well as upon demise of their family members. In the event one were to arrive at the international airport, for example, Jomo Kenyatta International Airport, it could result in the cancellation of flights, travel bans by various countries,
as happened by Israel a week ago, which we had to reverse it, in which they could ban people who had been in Kenya. In the event that were to go a health facility, people could stop seeking care in that facility, and others self-discharge themselves from the hospital in fear of infected. In the light of the public health risk, it could have been very prudent them to have an isolation facility that receives and treats these soldiers. The President, my lady, on the 26th of May 2026, was going to attend a conference in Brazzaville, Congo, or Congo Brazzaville, the Congo Basin Commission. However, as the Minister for Health, acting on the technical advice of the Director General and other technical persons, and in line with the Constitution under Article 123(2), advised against traveling otherwise, which upon his return, we could quarantine him for 21 days. He acted on our advice, and President delivered his speech virtually. But it is notable to state that those from settlers who were his advance team to Congo Brazzaville as part of the presidential delegation, upon their return, were quarantined for a period of 21 days in one of our quarantine stations. Notwithstanding the foregoing, and in recognition of the authority of this honorable court, I have directed the immediate and complete cessation of any intended construction, site preparations, or related activities concerning the Laikipia Air Base facility, pending the hearing and determination of the substantive petition, or until further orders of this court. I wish to say to this honorable court that I hold its orders in the highest regard and remain committed to the full observance. Honorable my lady, I want to say categorically, I have been a member of parliament for over 20 years. I participated in making many of the laws that the court is implementing. I was the first majority leader under the new constitution and appended my signature on over 1,320 pieces of legislation. Public servants, I will be the last person to disregard and will be the last person to violate any constitutional order given by any court. And I sincerely regret any action, omission, misunderstanding, or misinterpretation that may have resulted in a non-compliance with the order of this court or created the perception thereof. Thank you.
To emphasize the first and my lady, exercise your discretion in or as to the nature of sentence that may be imposed as against the Honorable Cabinet Secretary. My lady, in exercising your discretion, we urge you to consider that the actions of the Honorable Cabinet Secretary were done public. Indeed, there is absolutely no personal benefit that will be derived by the Honorable Cabinet Secretary in what would otherwise be a willful disobedience of the order. My lady, on the second hand, that is on the one hand. On the second hand, we understand that this court is also exercising public interest and protection therefore, is before you this morning is a balance between one form of public interest as against the other. In that balance, my lady, it is important that we draw our attention to the fact that the ingredients of content, in particular, shun against a willful and deliberate disobedience of a court order. From the affidavit filed before you and the explanation rendered by the Honorable Cabinet Secretary. Inadvertent error and genuine misunderstanding of the order of this court, and for which we ask that you exercise your discretion with leniency, particularly in favor of public interest. My lady, we also, without discounting the potential implications of what the order might have been intended to contain, very humbly submit that as we speak, we thank God that there's been absolutely no prejudice to any of the parties before you. We are absolutely in your hands. Because, my lady, this is a quest to protect public interest, we ask, my lady, with utmost humility, that the court finds that it is appropriate and sufficient to pardon any act by the Honorable Cabinet Secretary that was found by this Honorable Court to have been in breach of its orders. My lady, the court, and this is just a proposal, would even consider issuing a warning for any future possible departure from the orders that you issued. My lady, finally, and just for emphasis, we say all this because whatever action was taken by the ministry, as indicated by the Honorable Secretary, was undertaken on account of scientific guidance, on account of technical advice, and on account of what the Honorable Cabinet Secretary called strategic intervention, all of which are meant for nothing but the good of the Kenyan populace, considering the possible implications of the potential leakage of this very deadly virus. My lady, for those reasons that you consider humility pardoning the Honorable Secretary are most polite.
Your ladyship is just affirming the right.
My lady, if I could vary with the orders issued by this Honorable Court yesterday were very clear that the Honorable Cabinet Secretary avails himself for mitigation and sentencing. Malay, that supposes two things. That number one, a finding as to whether there was conduct or not has already been made, which was the primary business of the application that's before it. And secondly, that interaction is an interaction as between two parties, the court and the cited contemnor. What would cross-examination at this point serve? We asked my lady that you make a finding in relation to that request, that it is for this court to, number one, consider what has been presented before it, and number two, determine the weight of any issue that has been raised in the affidavit. And because, my lady, I say that the business currently before us is strictly between the court and the contemnor, if the court is of the view that it wants to confirm any aspect of any of the issues that are raised either in the affidavit of the Honorable Cabinet Secretary or in his highlight of what he considers to be pertinent aspects of that affidavit, it is for the court to make that finding, to aid it in determining what needs to happen. In any case, my lady, if we were to go the direction of cross-examination, we will still reserve the right to re-examine. That is not the business for which we are here to achieve before you. We ask with all humility, my lady, that you reject that attempt. And my lady, also dare to add that the proceedings that are before you would need to be conducted within the dignity of the court itself and within the respect of the parties that are before the court. I am most obliged.
The contemnor before you, the Honorable CS for Health, final affidavit dated the 22nd of June 2026. Your Ladyship, it refers to the in his wisdom, Your Ladyship, he decided to tender evidence before this court by way of deposition of an affidavit. He had a choice of tendering unsworn evidence for the court to consider, but as soon as the evidence is tendered under oath, under Article 50 of the Constitution, to a fair trial, the petitioners and the rest, the interested parties who support the petition, have a right to question, challenge, and affirm the evidence tendered by the Honorable CS. Cross-examination does not necessarily refer to an antagonistic process. It also includes seeking clarifications on the averments that are put therein in the affidavit. Your Ladyship, on my end, I'll take only 3 minutes to cross-examine the Honorable CS. Actually, purely on affirmations and clarifications on the content of the affidavit before you. Your Ladyship, we pray that we are granted the right to cross-examine. Much obliged, Your Ladyship.
Respondent is in content, then the next stage is what is the appropriate sentence for this court to make against the deliberate disobedience of the court orders issued on the 2nd of June. Maybe allow me first to start on the point that it is about the dignity of this court and the preservation of the rule of law and the need to safeguard constitutional supremacy. And it's not about the prejudice or any gain that the second respondent obtained. As we consider that the court considers four factors as it issues its ruling on sentence. One, is that the power to punish for content mandated is meant to protect the rule of law. And the courts have explained, allow me to rely on the decision of Justice Ndolo in Teachers Service Commission, as is the Kenyan National Union of Teachers of 2013, where the judge already found that the purpose of punishing for content, and when a court considers the sentence to men, it should issue a sentence that will preserve the rule of law. And secondly, that it is not about the ego of the individual judge or that of the applicant, but the main factor is that it is the preservation of the rule of law. The second factor that we ask that the court considers, it is the protection of public confidence in our constitutional governance. What will it mean to the public, when courts are seen to be making orders in vain? If this court allows that to stand, then the entire judiciary it will be exposed to ridicule, my lady. And once people lose the public confidence in their judiciary, the 2007 post-election violence rings a bell, my lady. We ask that this court he considers the words of Justice Chacha Mwita in Sheila Cassatt versus Anton Machata of 2021, where the learned judge Melody expressed that the sentencing it is about the preservation of the public confidence in our judiciary. And then the third factor, Melody, we ask that the court considers the deliberateness and continued breach of the court orders, Melody. This court, in its ruling at paragraphs 45 to 251, found that the second respondent was aware and that he had decided or chose to recharacterize the orders rather than stopping on what it was meant to comply with. And also, this court took note of the public sentiments that he had made, and really submit that these are aggravating factors. Fourth, and finally, Melody, we ask that this court he considers the constitutional status of academic secretary and the oath of office. Under Article 74, every public and state officer takes an oath where they affirm their allegiance to the Constitution, the authority case, which it was against the former President Jacob Zuma, when he was found to be incompetent, Justice Kampepe, while writing the majority opinion, said that when it comes to sentencing, the court must consider the office that Zuma held. And that you will find it at paragraph 123 of that decision. That among the factors is the status of the office of the colonial land. So, immediately then in conclusion, we submit that the appropriate sentence here it should be one that satisfies four things. One that vindicates the authority and dignity of this court demands the supremacy of the Constitution and rule of law. Third, a levy should be one that can deter the constitutional and any other state officer with such behavior. And finally, the third is one that can deter the container and any other state officer with such behavior. And finally, it should be one that can restore public confidence in, and that no person, no matter the rank or how mighty one may think to be, we are all below the law. My learned senior, Bumbo, Asami Ameledi, that you can just pardon him with a warning. Melody, that is exactly what Professor Mark Tushnet calls a constitutional hardball. He says, as one does something, knowing it is illegal, then comes to court and says, I am sorry, and then he is let to be. And then tomorrow he goes and does the same thing, knowing that the court, he will come and say sorry, and then that ends. As such, then, the sentence that he does is content and punishment for content exists as evidence submitted by the Federal Council to ensure that the dignity of this court and the constitutional order that we live in continues to exist. My lady, Senior Gumbo has ably submitted that the acts of the contemnor were done in public interest. My lady, nothing can be further from the truth. Contemptuous acts can never be in public interest. The submission, therefore, that the court should consider a balance of public interests as submitted to you by Senior Gumbo does not hold. It is in public interest that orders of this court
My lady, we humbly submit that this case is not a case for leniency. This is not borderline content. This is not a technical breach committed under ambiguity. This is a willful and deliberate disobedience of this court's orders. And that finding has to be found. Already, in purging content, rule as the court that a sentence in this matter and nature of content and conduct of this particular content has to be.
If there's anything else you'd like to discuss or need a different.
My ladies, if I can continue. And my lady, the applicant does not seek for this court to be vindictive in its sentence. The applicant asks of this court to be exact and impose a sentence that fits of the contemptuous acts committed, not what the contempt norm favors to be done in this circumstance. My lady, as to the prayers we will be seeking, we do agree with the first petitioner on a committal sentence of 15 months. Alternatively, my lady, we do urge this court to impose a fine and that fine should be reflective of the gravity of this content. My lady, we do seek that the contempt norm immediately purge his contempt by full compliance of the orders of this court, failing to which the committal order to take effect immediately. My lady, importantly, we do seek of the orders of this court. My lady, we have this.
We may not take a lot of time so that the people can start in earnest. Allow me to say this. One of the considerations for maybe the The sentence should be not to deter the temptation to disobey court orders in the future. Either by the condemned or any other person. Another person in authority knows, hears that if you disobey the court order, there is a serious sanction, they will obey court orders. That would be I've looked at the affidavit which has been filed. It was not shared, but it's how it is yet. And I have no doubt you have a chance to look at it. And you'll find that the content law does not speak about or even apologies at all for his public appearances. On 30th of May 2026, where he encouraged
that the CS for Health, the continuer herein, has come to court today. He has complied with the orders of this court to appear before it. By way of affidavit evidence, which is given under paragraph 12 and 13, he expresses remorse. Your Ladyship will be relying on the case of the Law Society versus the Inspector General of Police, 24, where the court, specifically our brother, the Honorable Mugambi, in ascertaining the appropriate sentence for the then acting IG, Masengeli, held that the demeanor of the contemnor in court is important. In the court ascertaining the veracity of his apology. The contemnor today appears calm. He appears very remorseful. It is manifest in his demeanor. We know him as a very combative politician. Your Ladyship, you don't see any combativeness in him today. It is an appreciation that he has abandoned the theater of politics and he has come to a temple of justice. Therefore, the government of Ethiopia holds that his apology is sufficient as a mitigatory factor before this court when it comes to ascertaining the leniency or otherwise. We further observe, Your Ladyship, that as part of his remorsefulness, he has not challenged the conviction that this court has handed over to him. He remains a convict, and unless he appeals, he shall remain so. It is an admission that wrongdoing was done. And that one is vital in offering him leniency in your sentencing. The people of Laikipia also take note of the fact that no harm has happened to its population so far. There is no case of Ebola that has been recorded in Laikipia County, and that was purely the intention of the county government when it joined these proceedings, to ensure that it protects the interests of the people of Laikipia. It is not interested in causing a crisis within the Ministry of Health by sending the CEO, the CS, in prison. It is interested in ensuring that the rule of law is complied with and the orders of this court are respected. And in the spirit of the Intergovernmental Relations Act, the county government appreciates the importance of coordination between the Ministry of Health and the county government in averting a crisis akin to the one that Ebola can cause. Your Ladyship, as I close, we hold that an admonishment to the Cabinet Secretary will be critical by this court, so that as he leaves this court, if at all he leaves, he goes and spread a message among his colleagues, including his employer, in senior ranks of government, that this court, at the time of protecting the rule of law, will assert its clause and perform its constitutional duty of defending the rule of law. The ladyship, that's not for the court interested party.
Others are not made in Delhi, and that the second respondent had a duty to obey the orders of the court. My lady, judicial authority flows from the Constitution, and the second respondent is duty bound by virtue of Article 2(1) and Article 10 of the Constitution to obey the orders of this honorable court. My lady has been asked to deploy a balancing act. And my lady, the question is, has the reason for non-compliance, or rather is the reason for non-compliance with court orders plausible? My lady, the answer is no. As such, we ask the court to uphold its authority and punish the continuing. That is all.
Question has been made by my colleagues about a continuing breach. Valerie, the affidavit that is before you confirms that the Honorable Secretary, Cabinet Secretary, issued firm orders stopping any continued development. Indeed, there's been a confirmation of compliance from the county government of Lake, that there is no continuing breach. So that is not accurate. Number two, your attention has been drawn to the South African authority in Jacob Zuma's case, where the court made a finding that was considered as one of the issues the office of the individual holds. Related to this, we say that it should not be lost on us that the Honorable Cabinet Secretary has been in leadership in this country for more than 25 years, and not once has he been cited for contempt. And so therefore that authority would not on all fours add value to what is carried before the court. Number three, there is the question that the Honorable Cabinet Secretary be condemned to personally pay the cost of this conduct. My lady, that will say that the facility that is in issue before you is a public facility. The actions that were taken and which have been found to have been in breach of a court order were public related or public interest decisions. The ruling jurisprudence, my lady, shunned away from missing out any punitive orders in relation to the party, including an order as to cost. Nowhere has it been alleged that the Honorable Cabinet Secretary took any action that in any slight way benefit him as an individual. My lady, you've been addressed about the authority wielded by the Honorable Cabinet Secretary. My lady, I take time to remind us that that authority also includes a responsibility to protect the general public from any potential harm in matters health. My lady, just to emphasize that, the Honorable Cabinet Secretary did indicate that the decisions they take are premised on science, they're premised on technical advice, and premised on strategic intervention. Those are the three issues that the Cabinet Secretary took into account in preparing the policy positions that have been taken. My lady, as relates to the question about apology not having been tendered, my lady, we should not forget that your orders were issued yesterday. And within 12 hours of the issuance of your orders, the Honorable Cabinet Secretary has availed himself in court and expressed remorse as to what has been found to have been an offending action. My lady, finally, there's been an allegation by my good friend, Mr. Waduta, in relation to utterances that have been placed, albeit out of context, in the hands of the Honorable Cabinet Secretary. My lady, because we have the Honorable Cabinet Secretary with us in court, we plead that you just give him 2 minutes to contextualize that issue, because it is important not just for this proceeding, but also for purposes of the public understanding what he meant. With the permission, you will be. Okay. Very well. So we stand guided. My lady, with that, we ask that you exercise leniency, balance public interest from a well-meaning state officer taking action on the basis of those who are qualified to advise him. On the one hand, and the interest of the people on the other. And find, my lady, that a pardon and a warning would be sufficient to serve the interests of the people of Kenya. And I dare add, my lady, that in matters of this nature, the winner is generally the people of Kenya. So with your orders, the people of Kenya have won. There is absolutely no other benefit to be derived by punishing the state officer who has demonstrated that the action they took was a good thing. I'm also glad. Finally, also, just in response to that, ask that you address yourself to specifically paragraphs 8, 7, 8, 9, and 10 of the affidavit. This one before you. They answer those issues in good detail. I am most obliged.
I had another matter which needs to proceed, and we also need to take directions on the substantive petition. So I'll just give my ruling now extempore, but I will, of course, give a detailed reasoned ruling. So I have considered, Honorable Duale, if you could kindly rise. Yes, I have had occasion to consider the affidavit that was submitted by the Honorable Duale. I have also considered his verbal submissions. I have taken very seriously the submissions by the petitioners and the interested parties on the weight that should be given and the duty of this court to safeguard the integrity of this court. I have noted that Mr. Duale has indeed submitted himself to the authority of this court. He has, as was required of him, tendered his mitigation, and I note he has rendered an apology. I will give my reasons. I will accept that apology. I have been invited to issue a warning. I will qualify that it is a strict warning and that any hint of non-compliance with the orders of the court will not be tolerated. Since it's the first instance that the minister is responding to this, I will give him the benefit of doubt that there was actual misapprehension of the court order. So for that reason, I will accept the apology that has been tendered, especially as he has been categorical that he recognizes the authority of the court. On costs, I will not order him to pay costs in his personal or other capacity, but in the same vein that the same is not to be repeated. So with that, the Honorable Duale is discharged with a stern warning. The sum of it is that the apology is accepted. There shall be no orders to cost. A stern warning is issued. Yes, so I will give a detailed ruling, but for the purposes of moving us ahead, that will be sufficient.
Naledi.
Yes, now we would like to take directions in the main petition. I'd like to confirm first, do I have anyone in petition E336? It's a related petition, and we were to mention it today for Patrick Omondi Okello. Frederick Omondi Okello. The advocate is Faith Moni Odhiambo. Okay. And it does not hold us, even in their absence. I'll just direct that petition. Just hold on, I give those directions.
All the reasons from the state that is Mercy Makai, 2nd of June. Such, my lady, I'll be requesting for 5 days to file my father affidavit, and for my colleagues, you can also allocate them 5 days to put in their submissions after I've served them. I think that is available. Yeah,
the same for you?
Responses after the 5 days, you could find other applicants. Definitely there are issues that we need to address and clarify together with the fitness allegation so that we don't change the indictment that have been given by the court. Therefore, we need a period of 10 days we can be able to exchange feelings. I have talked to counsel for the petitioner in petition ED.
We'll do so before on 23rd of July. Can we proceed virtually then?
Yes, sure.
For the avoidance of doubt, the orders are extended until then.
Okay.
Risk assessment.
I'm a free man, man.
Okay.
Yes.
This is the residential.
Hapana, mimi sasa niko free man. Nene wewe.